Welcome to the Roundtable. Thank you very much for joining us in a discussion, in a way celebrating the book launch of Internet Jurisdiction, Law and Practice. First of all, I would like to point out that I hope we have a very lively discussion after the presentations. And if you want to pose a question or comment or raise a discussion point, please use the Q&A functionality in the menu to post your question or your comment. I really look forward to an active participation, so I want to really encourage people to use that facility. There's also a chat room which is perhaps more for sort of social interaction. First of all, I want to thank the panelists, Professor Alisdair Gillespie and Professor Cedric Ryngaert and Professor Daithi, who have joined me in this roundtable. I'll make a few introductory remarks, and then I will hand over to Dai, who will chair the session and shape in many ways, hopefully, our discussions. Just a few remarks to the book. In many ways, it has been a very crazy undertaking because I decided quite early on to write a book on jurisdiction, which goes across public and private law questions of jurisdiction, which I think few people have approached this particular topic that way. I guess Professor Dunn Swanterson would be an example, but usually questions and discussions of jurisdiction are obviously kept separate between, say, in the criminal law context and the private law context, say contract, or even in the regulatory context. My background is as a technology lawyer, so I think what really started to fascinate me from the early days of my PhD was really the question, how do we deal with the conflict between a communications medium which by its very nature crosses borders and legal regulation, which is obviously focused on a particular nation state with obviously some interface with international law. So in many ways, it was an ambitious, or some people might say foolish project, but I still think it was the right approach. And I hope that the book actually brings some of the common themes, which are perhaps, if we look at these topics separately, are often overlooked. So, for example, the question of targeting, or the question how we locate conduct online. So both in respect of tort as well as crime, the question often will be, where does the conduct take place, or where does the damage or the result of a crime occur? And I think some commonality and some parallels can be drawn here between criminal and civil law. So the other insight I gained through writing this book, I think a lot of people who write in this area hope to find better rules governing some of the jurisdictional challenges and the jurisdictional conflicts. And the idea is setting out with the idea of law reform. But I guess I got very frustrated with this topic in many ways, because it's very easy to point out deficiencies of the law in regulating and in dealing with questions of jurisdiction. It's much harder to try and formulate better rules. And in the end, I think one of the little insights I did gain was that perhaps this isn't about rules, but it's actually about system interfaces, and that in many ways, the law interfaces with technology system, it interfaces with geopolitical realities, and the law itself cannot overcome the problems which arise from these interfaces. So we need to think outside the box of law. And hopefully this is something which I think the book illustrates in this way. The other thought I had that, I mean, this is not new, other people have said this too, but I think it comes up in the area of jurisdiction, the increasing interconnectedness of the world, in a way makes it even more important that nation states cooperate in order to improve these interfaces between different legal systems. But ironically, I think this increased interconnectedness through the internet has led to a populist backlash against internationalization at a time when perhaps we need it most. So I think the whole debate, and then when Brexit happened in the UK, which was roughly at the time when I was writing this book, I thought it's a very good illustration of this very problem. Ultimately, the other insight, I guess, which I got from writing this book very much was the connection between fundamental rights and jurisdiction. Jurisdiction is important and it matters because it's bound to the rule of law. And the rule of law in itself, I think, is bound to the question of fundamental rights. So simply to transfer some of the legal issues in relation to the internet to the private sector and say we can replace national regulation to self-regulation or regulation by contract, I think is too simplistic precisely because it defeats the rule of law and fundamental rights. I think that's especially obvious in the question now of law enforcement powers in gaining investigatory data from foreign service providers. While we can set up systems which allow this type of exchange between states, it's much harder to provide for legal redress and the safeguarding fundamental rights, which I think is probably one of the conclusions from my examination of jurisdiction. Without much further ado, and I would like to hand over to Dai as the chair of these proceedings. He is obviously one of our leading technology law scholars at the Queen's University in Belfast, and I look forward to our discussions.
Thank you very much, and indeed, I very much wish to welcome so many of you who've joined us, well, this afternoon here in the United Kingdom, but in many other time zones around the world. We've got over 100 people on our virtual meeting or event this afternoon, and it's a source of great pride to be able to welcome you and to chair our discussion. We're celebrating the publication of this book on internet jurisdiction, and I just want to say a very short comment about it before introducing our speakers, who will offer more detailed thoughts and reflections. As Julia has already said, this is a distinctive book in how it seeks to address aspects of public international law, of private international law, of criminal law, and so forth, and to weave the technological story through it. What struck me when I had the opportunity a few weeks ago to read the book for the first time is how this is a story of technology in its social, economic, and cultural context today, spanning a wide range of areas of law. So we see tales of the regulation of broadcasting and audiovisual media, a topic very close to my own heart. We see the much discussed and perhaps much feared GDPR, but we also delve into privacy, crime, intellectual property, and those layers of how jurisdiction is or isn't dealt with reflects the way in which the topic of internet jurisdiction has spanned the lifetime of information technology law or of cyber law, taking some of those earlier concerns or even panics around the role of the legal system and the rule of law, followed by perhaps some settling or a lack of attention, but from today's perspective, to see how fundamental this is to legal and regulatory design, where new instruments are being adopted, where major points are being considered. Those kind of really important questions of jurisdiction are still there. And it's only in a work like this that is so informed by a deep understanding of the technological context, but also the multiple doctrines and legal schools of thought where this question just pops back up. It really tells us how how much has happened, and yet in some ways how little has happened, and how an understanding of the role of jurisdiction in the validity, in the acceptability, in the legitimacy of a legal understanding of technology is right there. So this book makes a terrific contribution to our understanding of the field, and raises a bunch of questions which we'll be able to dig into over the next while. But you'll be glad to know I'm not doing that digging. And so I can, at this stage, introduce two esteemed panelists, each of whom are going to speak to some of these themes for about 20 minutes, followed by an author's response, and then a chance to ask your own questions, and we'll capture as many in the Q&A as we can. I'm sure many of the participants today will be eager to do that. So let me say something about today's speakers. Speaking first will be Professor Cedric Reinhardt from the University of Utrecht, where he is Professor of Public International Law and carries out research in areas including jurisdiction, non-state actors, and other areas of international law. His research has been funded by the NVO and the European Research Council. He's the author of a number of books on jurisdiction, including Selfless Intervention, the Exercise of Jurisdiction in the Common Interest, also published by Oxford University Press and published last year. And in a moment, he will make his remarks on these themes and on this excellent new publication. He'll be followed by Professor Alisdair Gillespie from the law school at Lancaster University, where he, as well as being Professor of Law, he's Deputy University Dean for Academic Quality. His research interests are in cybercrime, with particular expertise in terms of academic work and also advisory roles in the legal and regulatory issues surrounding child sexual exploitation. His recent work has been published in outlets including Cambridge Law Journal, the Modern Law Review. He's currently working on a British Academy project on restorative justice for victims of online child abuse images, and he's the author of the well-known book Cybercrime, Key Issues and Debates, published by Routledge, and a co-author of a major work known to many law students on the English legal system. So at this point, our two expert speakers will make their remarks. We'll return to Julia in due course for a response, and then we'll have plenty of time for a question and answer session. So without further ado, Cedric, I will pass the floor, the microphone, and the virtual space across to you.
Thank you, Daithi and Julia, for the kind invitation. And first of all, I would really like to congratulate Julia on her excellent, timely, and wide-ranging book. So she addresses questions of internet jurisdiction in really very different fields of the law. And these fields, as she also pointed out, they're normally studied by area specialists, say you're a civil lawyer, or a commercial lawyer, a criminal lawyer, or a data privacy lawyer. But she does everything, she does it all. And she also tackles 3 dimensions of jurisdiction, like prescriptive, enforcement, and adjudicative jurisdiction. So this is great. I mean, this is definitely no small feat. I envy her that she was able to pull this off. And all of it is crowned by a very fine conclusion in which she connects the different argumentative lines and threads. And she draws attention to changes in the applicable jurisdictional rules, but also, as she pointed out in the introduction, more systemic changes, like the need for more coordination, the rise of geo-blocking, and private systems taking on governmental functions. So I only have one advice, read the book. And what I found particularly refreshing is Julia's plea for a fundamental rights approach to the law of jurisdiction. She also just mentioned it. And indeed, the law of jurisdiction has traditionally been concerned with delimiting spheres of competence between states. I mean, it was all about state interests, and we paid little attention to individual rights. And to just give you an example from the internet jurisdiction domain, and Julia hinted already at this, states are now adopting agreements allowing each other to exercise extraterritorial jurisdiction via so-called production orders. But then the question is whether in doing so they perhaps forget about individual rights, including procedural rights or right to a remedy. And I believe from this perspective, Julia rightly criticizes, for instance, the proposed European production order as it may give data subjects insufficient rights. You know, these data subjects, they cannot really complain about breaches before their own courts, but they'd have to go to the state issuing the extraterritorial production order. So this is not really desirable, and hopefully in the new version, this will change. At least that's also the position of the European Parliament in this dossier, and I'm sure they will listen carefully to what Julia has to say, and will read her book. My own disciplinary background, as Daithi has explained, is in public international law, so we'll reflect on the issues from the public international law perspective, if you allow me. I'm not a tech lawyer, so I'm a general international lawyer, although I'm a bit familiar with the technological challenges at stake here. I will not discuss the private international law issues. They're also addressed in the book and at length. They were supposed to be discussed by Lorna today, but unfortunately she couldn't make it. But I will focus mainly on the criminal law. There might be some slight overlap with Alisdair's presentation. I understand that he will also address the criminal law, but mainly from an English law perspective, quite probably, whereas my perspective is an international law one, so our presentations should be complementary. I will proceed in two steps. First, prescriptive jurisdiction, and second, enforcement jurisdiction. So first, prescriptive jurisdiction. So this is about the application of a state's criminal laws to cyber activity. And as an international lawyer, what strikes me if I read the book is that there is no fundamental jurisdictional shift going on as regards prescriptive jurisdiction. Of course, you know, it's more difficult to locate crime in a borderless world, in a deterritorialized or unterritorialized internet. But this is not new, you know. Throughout the 20th century, regulators and courts, they have grappled with the exercise of territorial or extraterritorial jurisdiction over transnational business transactions, sort of the first wave of globalization. And these transactions had links with multiple states. And states then wish to exercise jurisdiction over such transactions, and they have relied on various principles like the ubiquity principle, the constituent elements approach, or the effects doctrine. And basically, the idea is that as soon as an element of a crime can be linked to a state's territory, that state can exercise territorial jurisdiction. And over the years, states have really been quite inventive in this regard, quite creative. And such inventiveness is obviously brought into even starker relief as regards internet jurisdiction, because there components of cybercrime are scattered even more geographically. But again, by and large, there is not really a departure from the existing approaches to jurisdiction. And I also gather this from Julia's discussion of prescriptive criminal jurisdiction in Germany and in England. You have courts hearing cybercrime cases, but they appear to apply existing criminal law doctrines regarding jurisdiction. Now, sure enough, their application in practice may be challenging, but and interestingly, there's this shift, or there may be this shift, maybe Julia can say more about this, towards this targeting approach, especially in publication cases. So states only exercise jurisdiction over persons who deliberately target criminal content at local territorial-based users. And I believe that this is a welcome development, as it weeds out jurisdictional assertions over foreign activities that only have incidental territorial connections. And it's also interesting to observe here that one sees some kind of cross-fertilization from the field of private international law, where targeting has been relied on in consumer law cases for quite some time already. But what targeting precisely is may remain in the eye of the beholder. Of course, and Dans Fanderson has also criticized the targeting standards on these grounds. But more fundamentally, what strikes me is that Julia does not cast doubt on the viability of territoriality as the overarching basic principle of jurisdictional order, whereas other writers in the field, to mention again, Dans Fanderson, they have criticized the use of territoriality in internet cases as a jurisdictional principle. But at the end of the day, we see that legal and political practice continues to rely on territorial sovereignty, and we cannot wish that away, you know. And at one point, Julia also observes, and she relies on the private law theorist Günther Teubner, that the law, and I quote now, must be interoperable with its surrounding systems, and here of course we talk about technology, disruptive technologies, yet remain compatible with its own values and internal structure, end quote. And one of the main structural principles is of course the principle of territorial sovereignty. And territorial sovereignty, territoriality has certainly not disappeared in the internet era. So just look at techniques of geolocation, geo-blocking, which may ultimately lead, of course, to a balkanization of the internet along territorial lines, although it could be in the interest of commercial operators as well to limit liability. And also we know full well that in a number of autocratic regimes, certain international websites are made unavailable, inaccessible, a form of censorship that is based on territorial control. Let me now move to enforcement jurisdiction. That is the second part of my presentation. So as I just explained, for prescriptive jurisdiction, I do not see a fundamental shift. But regarding enforcement jurisdiction, I do see a fundamental shift. Now, in the law of jurisdiction, enforcement has traditionally been considered as territorially bounded. So law enforcement authorities can only carry out investigative acts on their own territory, right? And so we talk about a strict prohibition of extraterritorial enforcement jurisdiction, and that goes way back to the 1927 Lotus case before the Permanent Court of International Justice. And my claim, and I also think Julia's claim, although she's not very explicit about this, and I invite her to reflect on that perhaps during the discussions, is that this strict prohibition may now be under pressure, and that in fact new customary international law may be crystallizing. So let's make it concrete. What are we talking about? So we're talking about law enforcement agencies wanting to access data which is stored abroad. And as the data is stored abroad, well, they would normally have to submit a request to the state where the server is located, and mutual legal assistance, MLA. There are treaties on this, bilateral, multilateral. But this takes time, as Julia points out, it's very cumbersome. Sometimes it takes 6 months, sometimes 24 months, so you don't want to wait that long. So there's a wish to do it unilaterally. Yeah? So states issue production orders aimed at internet intermediaries controlling these data. So that's a form of unilateralism, bypassing the state. And sometimes they even directly access these data via hacking techniques or network searches. So that's, of course, very invasive. I'm not going there during my presentation. Maybe Alisdair will do that. The question then is, for all of us, does a prohibition of extraterritorial enforcement jurisdiction bar such action? And does it prohibit such action? Is it lawful or is it unlawful under public international law? It might, of course, be lawful under domestic law, but I'm talking about public international law here. There's an interesting discussion, by the way, of the Supreme Court of Norway in 2019 on this issue. I'm happy to share the reference with you. I recently came across it. And in this case, the Norwegian police had validly obtained access credentials from a music streaming company, and it used these credentials, log-on details basically, to access data which were stored abroad, Amazon Web in the United States and servers elsewhere in Europe, European Union. And the court decided that there was no violation of a foreign state sovereignty. And basically the court explained, well, the link with Norway was sufficiently strong to grant jurisdiction, because at the end of the day, jurisdiction was exercised over a Norwegian company, Norwegian-based employees. By the way, this is also the position of the Tallinn Manual 2.0, to just say it's territorial jurisdiction. It's not extraterritorial jurisdiction. But here's the thing, right? There is no denying that the relevant data is stored abroad, on a server abroad. So eventually, what Norwegian law enforcement authorities are doing here is to access evidence which is located, for all intents and purposes, in another country, without asking for the consent of that country. So they bypass the consent of the territorial state. And I'm not quite sure whether you can get around the prohibition of extraterritorial enforcement by saying, well, it's simply territorial jurisdiction. So I don't know what Julia thinks about this precisely. But in any event, especially in Western countries, there appears to be a tendency to allow such orders for the production of evidence. These orders are then typically directed at entities based on the territory. That's the Norwegian case, or they are directed at internet intermediaries, Google, Facebook, Skype, offering services on the territory. And in 2019, for instance, the Supreme Court of Belgium, my own original home state, confirmed that Belgian law enforcement authorities, the Belgian police, could order Skype, which was based in Luxembourg, to submit data and even to install a wiretap for eventual use in criminal proceedings in Belgium. So that was not considered as a violation of a foreign state sovereignty. And as you may know, currently there's this proposal for the European Production Order. There's also the US Cloud Act. And interestingly, from a public international law perspective, states seem to justify these extraterritorial production orders by relying on principles of prescriptive jurisdiction, like the effects doctrine or the personality principle. But if we believe that extraterritorial production orders can be presumptively valid, the next question is, how can we limit jurisdictional overreach? And I believe that's a very important question, because the last thing you want is that a state can just order the production of any data located abroad. You know, autocratic states could easily abuse such a permission to collect data on their opponents. And even in democratic states, fundamental rights could be compromised. As Julia points out, mutual trust only reaches so far. So what we see is that states indeed seek to limit the reach of their jurisdiction, and they rely on fundamental rights, but they also rely on flexible, malleable concepts like genuine link, comity, reasonableness, which they take, again, from the law of prescriptive jurisdiction. So the upshot of all this, for me, is that the traditional boundaries between prescription and enforcement seem to be dissipating, and perhaps a new type of jurisdiction, investigative jurisdiction, may be crystallizing with its own rules. Concluding, I repeat, it is Julia's great achievement to have captured so many dimensions of jurisdictional discussions in just one monograph. And internet jurisdiction, of course, remains a moving target. And as a result, as far as I'm concerned, the most interesting jurisdictional questions these days arise in a cyber, in an internet context. But it is my hope, and I think that's also Julia's hope, that states quite soon, hopefully, can reach some form of agreement, possibly by treaty or another agreement on jurisdictional questions in the interest of legal certainty, so that states know what they're allowed to do, so that private operators know what to expect, and also so that individual rights can be adequately safeguarded. Thank you.
Thank you very much for those remarks, and quite a number of them I'm sure we'll return to in the discussion, including your concluding point on an international agreement. I'm sure, again, given the range of the audience range, have particular responses to that, and we look forward to it. For those who've just joined us after the celebration of this book has begun, please do use the Q&A function, which you'll find typically at the bottom of your screen, and we'll collate questions during the presentation and handle as many of them as we can towards the end of today's proceedings. So having heard from Cedric, we now pass to Alisdair Gillespie at Lancaster University Law School, who will now make his remarks on this book.
Great, thank you very much, and thank you to Julia for asking me to do this. As you said at the beginning, I've got the dubious distinction of being a deputy dean now, so it's quite nice to attend something like this and remember I used to be an academic, and that I used to actually be able to do some research and read interesting things rather than write policy papers and try and work out what Boris is going to do about students either coming, going, or not coming or going to universities, which seems to be most of what I do now. It's a real shame, although an ironic shame, that of course we're doing this by Zoom, and that, you know, ordinarily we would all be in London talking about this and no doubt having a glass of something suitable afterwards, although I still intend to do that, given the day ends in a Y. But, you know, in a way it shows also how easy these things are. I think over the last year, we've all got used to doing all sorts of things by technology, including across the jurisdictions. And I think that's what makes it so interesting, that there's this book, that technology constantly adds new things and new opportunities for us. But it also raises interesting questions about whose law should apply in these things. And I think Cedric's given some very interesting insights there that, at the higher international level. I do quite a lot of training on cybercrime, and I'm normally asked, you know, when will we ever crack cybercrime? And I normally answer it in two ways. One is I tend to say not until after I've retired, please, because otherwise it would do me out of a job. But the second thing is, I always say, really, the one thing that actually stops us from ever really tackling cybercrime effectively is jurisdiction. You know, and jurisdiction in all of its guises. And I think not many people get to grips with jurisdiction. I think that's why this book is so important and interesting, that, you know, it's a very approachable book that deals with a very crucial element. It's very easy for us to say, oh, there should be a law on that, or why doesn't the law do this, and all the rest of it, without ever kind of thinking about the implications of that. I think one of the things I like about Julia's book, to some degree, Cedric said it in a different way, not necessarily as approving as me, but it is that it's based on the territorial principles. I think those of us who know a lot of this literature realize that in a way there's a bit of a divergence between computer scientists and lawyers. So kind of on the early days, and to see even now, a lot of the computer scientists have this desire for the internet to be an international space, you know, so that international lawyers would say that that was akin to, you know, Antarctica, outer space and the high seas kind of thing, and things like that. And we should have this. And there's been some remarkable writings about this, including, you know, that the ICC, for example, should have jurisdiction over internet. You do wonder how often they would have the ability to hear all the cases that relate to cyberspace. But I think where Julia's right is that it's a recognition that that might be a good theoretical argument, but it will never apply in practice. And I note in the preface of the book, Uta Cole says that the book made her think about sovereignty. And of course, we've heard of sovereignty quite a bit over the last 2 or 3 years for those of us in the United Kingdom. But it's true. You know, jurisdiction is inevitably wrapped up with sovereignty. And that's why the territorial principle really remains the cornerstone of this, because in order to allow a kind of international space aspect like the high seas or outer space, it would require countries to surrender sovereignty over what happens in their territory. Because whilst we like to think about cyberspace as kind of being noughts and ones constantly floating around us all the time, and we see those kind of maps of digital streams going everywhere, we've got to remember that that's not true. You know, the internet is a series of servers, and those servers are based in countries. You know, Google experimented about using data servers outside of the 12-mile remit once, which was quite an interesting idea, because you kind of got why they happen to have all these experimental barges 13 miles outside of various territories. But at the moment, you know, they are based within territory, and that really means that countries are going to continue to want to assert their sovereignty, and their territoriality becomes incredibly important. And of course, it's not just about what happens within their territories, it's also about what happens to them. But I think jurisdiction is interesting because, you know, there's the different types. So Brenner has previously said, you know, when we talk about jurisdiction, there's actually 3. There's the jurisdiction to prescribe, the jurisdiction to adjudicate, and the jurisdiction to enforce. And I do like the fact that Julia tries to address all of those elements, because again, quite often it's very easy to say, oh, well, we should prescribe X or we should prescribe Y, but it's how do you do this? How do you get all of these things? And like Cedric has said, I think the whole aspect about investigation becomes really important. And I do think in addition to Brenner's 3, you could now have the jurisdiction to investigate, because we now almost have this idea now whereby, as Cedric said, we've got this idea about we have the right to just tell round to companies and say, give us the data, or how do you get that data? And the reality is, particularly in crimes, unless you have that data, you are not often going to be able to enforce the law that you've created. And it goes beyond cybercrime, of course. You know, I think what is a cybercrime has always been an interesting discussion for many of us. But of course, most crimes these days have a cyber element, you know, and therefore, to some degree, the digital evidence and jurisdiction around digital evidence is almost becoming more important than what we traditionally think about of jurisdiction, which is the jurisdiction to prescribe laws. And I think, again, there's some very interesting passages in Julia's book that really helps make that understandable. In terms of challenges, though, for prescription, again, Julia notes that there's two principal challenges. So you've kind of got the multiple overlapping jurisdiction, and we think about things like WannaCry, you know, and if you set aside the potential that might have been North Korea doing something, you know, if you could identify the individual, WannaCry infected computers in 150 different countries. You know, so does that mean that all 150 countries could seek to prosecute the same individual, and in which order? Do we do pass the parcel? You know, where one ends, the other picks on. And I think that becomes a really interesting question, because at what point is it decided enough is enough? And then the second one, I think, you know, this is the one that many people have concerns about, is jurisdictional overreach. You know, and that's not a new thing. You know, to some degree, there are a lot of people who used to check flight plans very carefully to find out whether it went through the American territories. You know, if you're an online gambling casino boss, you kind of looked pretty carefully about whether or not you could there's any danger you might change planes and be arrested. And I think that really does show the two issues. So why is the first problem, multiple jurisdictions, a big problem? It's because of that territoriality. It's because we seek to enforce things within our territory. And whilst we do talk about extraterritorial jurisdiction, quite often in cybercrime, we don't rely on that, because we always say there is a link to territory. And that's either through how we deal with it in terms of things being within our jurisdiction, or we start applying it to our citizens or even our residents in some instances, where we'll say if one of our citizens or residents commits an offence that has an action abroad, we will deal with it, or vice versa, somebody affects us. And that means, in a way, the territorial jurisdiction becomes really quite important. But what I really liked in the book was where Julia tried to deal with the bit that a lot of the instruments are silent on. So she mentions, for example, the Cybercrime Convention, first, you know, very crucial international instrument that really decided that. And there's a wonderful Article 22 that says how we should deal with jurisdiction. And at the end of it, it kind of says, oh, by the way, if more than one of you want to assert jurisdiction, just go and have a little chat. And that's kind of what it says. It just says, you know, have a negotiation, you know, try and see if you can be nice and play nicely together, sort it out. And yet, how do you resolve that? And that is one of the biggest challenges we have with this. You know, and obviously, in the past, Cedric, for example, has talked about comity, you know, and the importance about how we do this. And Julia herself goes through, you know, approaches that the EU have adopted about trying to work out who goes first as well. But, you know, you get the sense that, again, it's one of these things that's easy to say, but incredibly hard to do in practice. And we're back to that idea, as we often are in the international arena, of the big boy and girl and the little boy and girl. So actually, if the big, powerful country wants to go first, funnily enough, the big, powerful country tends to go first. You know, and whilst we might be happy to negotiate between, for example, whether America or Britain should go first, we're sometimes less confident about whether we want Britain or Vietnam to go first. Or, you know, and that can be important in sexual offence kind of cases where we don't approve of their punishment, so we don't think it goes enough. So we suddenly say, well, actually, it's okay, it's our jurisdiction as well, and we will deal with it. And it does become quite difficult to work out how we all do that. I would love the idea that we might be able to have a treaty to resolve these matters, but I'm always slightly skeptical about that. So, you know, it's been pointed out that a lot of my work is in relation to child sexual exploitation. And I make the point that if we use the term child pornography, which many of the international instruments do, I know, you know, it's a contentious term now, we should use CSAM and all the rest of it. There are, you know, the UK is a signatory to 5 different international instruments that all prohibit child pornography and all define it slightly differently. You know, there are numerous international treaties that seek to tackle child pornography, and yet we can't agree what it is. And actually, you think, well, actually, that's something that most countries will probably think should not happen. And if we can't agree on that, how are we ever going to agree on a treaty that will decide on things like who will go first? Because again, it goes to that essence of sovereignty. You know, so Uta's point about this all being sovereignty, we all like the idea of creating an instrument that says how we're going to do something, but not if we're not going first. You know, it's a bit like the jabs at the moment. You know, we quite like the idea of sharing everything out as long as we get ours first. You know, as long as another country gets it first. You know, and what we're seeing is this idea that sovereignty, it's easy to say we're going to share, but actually when it comes down to the hard practicalities of it, sovereignty is something that states are very reluctant to go against. I think the issue about double jeopardy is also really interesting. You know, and it's interesting, the Toby Studebaker case is quite interesting. The US Marine who, you know, groomed a 13-year-old girl and took her to Paris. He was then prosecuted in the UK for child sex offences and child abduction. And when he'd served his time here, he was extradited to America, where he was charged with the same offences. And it's because, of course, the US, like England, recognises dual criminality and double jeopardy in relation to its own offences. So where there's 2 jurisdictions, they consider them to be separate offences. And that really does raise interesting questions, again, about how are we going to resolve multiple jurisdiction claims? Because you could see somebody being passed around and getting, you know, quite disproportionate aspects. And we've never really got our hands worked out how to do that. Again, because it would mean that a country deciding it's okay, somebody else has dealt with that. And that might be okay in relation to malware, but it's unlikely that it would apply to sexual offences, for example. It's unlikely that any politician or political leader is going to turn around and say, it's okay, you harmed one of our citizens, but don't worry about it. You were prosecuted in that country, so we won't bother. Oh, sorry, everything went blank then, but it's okay. I think I'm back. It's obviously the WannaCry people are trying to get me to shut up within the next minute or two. And then really the one that I think is the most interesting is the second one that Julia mentioned, which is Overage. And that really is, I think, where a lot of this interesting discussions come about, because countries, particularly, you know, for an example, England and Wales, will decide that anything that's available to our citizens is justiciable in our country. And that really is interesting when you think about things like obscenities, you know, so the case of Perrin, you know, whereby material that was lawful in another country was breached our Offences Against the Persons Act and that's Obscene Publications Act, and you had OP in the title, because we had custody of the suspect because he lived in London, then we would deal with that as a matter, and that's then quite challenging because it means potentially we are dealing with other countries' moralities. We're deciding that, we are going to be influenced by others. And I think that's one of the real challenges. And of course, one of the challenges behind it is sometimes it's necessary to do that. So for example, Shepard and Whittle is quite an interesting case, I think. For those of you who don't know it, this is two people who produced racially offensive material. And they uploaded it to a server in America, where, of course, the First Amendment would protect this kind of material. But it was quite clearly produced in England, and it was targeted at England. So all of the advertisements, all of the directions and everything was towards people within England. So to some degree, if we didn't have that ability to deal with things within it, Shepard and Whittle would effectively circumvent English law by placing something outside of the jurisdiction. So in a way, the law that can be an overreach in the cases like Perrin is also what allows us to allow people, to make culpable people who do acts in this country that could allow evidence to be set aside. And I think the whole idea of overreach and how we deal with material that's accessible across borders is very interesting. And it's not just a theoretical argument. We see from the GDPR, we have the same thing. There's a number of very small news sites in America you can't access here because what they've done is blocked EU citizens, so they don't have to worry about the GDPR. And that's just a very simple example of how we are starting to have to work out how are we controlling things, how are we parceling up these things. So I found it a really interesting book. I thought what was interesting is Julia's managed to do two very unique things. One is make a law book interesting, and second, make a technology book interesting. But it's a very readable book. It's an excellent book, and it really does, bring law and practice together in an area which isn't easy. The one thing I would say, and I think this is the challenge, for jurisdiction, is the relationship with extradition. It's kind of sibling. And I think, what I've said a couple of times in this, and I think where it's a little bit hidden sometimes, is it's very easy to talk about jurisdiction, but unless you get hold of the suspect, how do you do it? And that's always the real tension with this jurisdiction, is actually how much of the issues are about jurisdiction and how much of them are about actually securing the suspect, and therefore it's about extradition. But I will shut up there because I've talked on for far longer than I thought I would. But congratulations to Julia, and thank you very much for inviting me.
Thank you, and thanks to those who have started sending questions in. We'll look forward to working through some of them in a few minutes' time. I alluded earlier on to shared interest in the European regulation of audiovisual media services, but one of the key achievements of European media law has been the right of reply, and therefore I asked the author to exercise her right of reply at this point to our discussion thus far.
Thank you, Doug. Obviously, where do I start? I'll come back to some of the points raised in both presentations, which I thought were really excellent and thoughtful, and did the amazing thing of, in about 20 minutes, summarizing a huge and complex area and pointing out some of the topics and issues which link the book together. So the first sort of thing I noted down was Cedric talking about targeting, and does targeting actually help to limit sort of jurisdictional reach in terms of territoriality. I think there's also an interesting distinction between the common law here and actually civil law jurisdictions, because I guess if the common law to some extent has started in Great Britain, I'm talking now hundreds of years back, and Great Britain or the UK, depending on what historical period you're looking at, has always been an island. Extraterritorial jurisdiction had a different meaning than when you look at, say, Germany, which in, say, the 17th century was a load of very small states and very small towns which had jurisdiction. And clearly, therefore, I think the concept of jurisdiction has evolved differently, say, from the common law perspective to the continental law perspective. So I think there's been more focus on territoriality and a strict territoriality doctrine in the common law than there has actually been in the civil law, where extraterritorial jurisdiction has been more recognized, and certainly I think, and Cedric may agree with that, I don't know, it has not been necessarily seen as illegal under international law. Now, targeting tries to limit jurisdictional overreach, and I actually had a discussion with Chris Reed when I was writing the book, and I said to him, where did this doctrine of targeting, which comes up in so many different contexts, it comes up in the consumer jurisdiction, you know, Pammer versus Alpenhof, and even before then, obviously the Brussels regulation and its special rule on consumer jurisdiction, where you have to prove that the business targeted or directed its services to the consumer's jurisdiction. It's contained there, but then it's also obviously been discussed in various permutations in the context of the criminal law. It's been discussed in the context of IP jurisdiction, even so it's not contained in Article 7 of the Brussels regulation. So targeting has sort of come up in different places. I think its origin really goes back, funnily enough, to, in a way, the US common law, where obviously in the civil jurisdiction context, it has been used to limit civil jurisdiction in tort cases in the sense of the minimum contacts doctrine under the US Constitution. So it has, in a way, a very different, almost constitutional law-based origin, which was then transplanted, I guess, partly by the discussion at European level at the time when the Brussels regulation was going through its process, as well as obviously the e-commerce directive. The targeting was discussed as potentially a suitable limiting concept. But of course, again, it doesn't really get around the very difficult concept of connecting someone's conduct and someone's intention to territory. So it doesn't get around the territoriality doctrine. It just tries to, I guess, provide fairness in a way between the parties by looking at what was the intention of the defendant, say, in a civil case. So territory, but what I found interesting, this discussion whether we should simply give up the territoriality doctrine, I think that's I think perhaps one of the insights of the book, that this is not the point. It's not about legal rules. So I took here some insights really from systems theory, and obviously we have different legal systems, so they in a way are independent of each other and separate from each other. So, you know, different legal systems are separate, and in a way international law, or private international law to an extent, provides the interface between different, obviously I'm stating the opposite, between different national legal systems. But of course, international law is very closely aligned to geopolitical concerns. And as Alisdair said, you know, we have, in theory, in legal theory, all states are equal, but of course in practice, and certainly in a political sense, they're not. But we also have different systems between the legal system and, if you want, the technology system. So, you know, the Facebooks of this world are also a system which in some ways are, to a certain degree, are independent of national legal systems. So systems, my application of the systems theories doesn't just relate to different legal systems, but it also relates to different social systems. So you could regard technologies such as cloud computing or social media platforms, I think, as a separate system. And again, of course, there's an interface, because there's a threat of regulation, there's a threat of enforcement. To some extent, technology systems will take heed of the law, but only to some extent, because actually, to some extent, they're also independent. So changing the territoriality doctrine in terms of legal consideration legal doctrine, won't change any of the other systems. So that's why, to my mind, a discussion of the viability of the territoriality doctrine is wasted effort, because it's almost like you're trying to change another system through making changes in another system. So that's why I guess in the book I use the German fable of the Baron von Münchhausen, who, when he gets into a bog with his horse, he pulls himself up on his own hair to lift himself out of the morass. And of course, that's precisely what we're doing if you want to change the territoriality doctrine. Because what do we replace it with? It's a geopolitical system which dictates sovereignty and which dictates the territoriality doctrine, at least as we know it at the moment. This might have changed in 50 years, but not at the moment. The other issue which came up is whether investigative jurisdiction as part of enforcement jurisdiction we should look at this separately and distinctly. I think it's interesting that there are, again, certain practical realities, as I think Alisdair pointed out. Obviously, in a modern age, most crime might have some evidence which sits in the cloud. So the access to investigative data of foreign service providers is obviously not limited to cybercrime. It's probably an issue which arises in many, many crimes, simply because the nature of our communications and the fact that most communications now sit potentially in a foreign territory in the cloud. So in reality, I think states they almost have no choice if they want to prosecute any crime. And I guess if we uphold the rule of law, we have to prosecute crime, then they almost have to use techniques which are extraterritorial, whether that's hacking or network exploitation. And so they almost have no choice but to legalize such methods under national law. And then I think ultimately international law follows suit. If we want to prevent that, I think perhaps the lesser evil is a system of production orders, because I think those are the two realistic alternatives. I know if you have any human rights lawyers in the audience, you probably want to scream out at me, and I accept that from a human rights point of view, but I think it's the reality. So there is an uncomfortable limit, I think, to the rule of law in the area, for example, of spying and the activities of intelligence agencies. And this is not something I cover in the book, and I'm not an expert in either, but I think increasingly we see, and this is again an unfortunate development, it's not a positive development, we see an overlap between the activities of what traditionally would have been intelligence agencies and criminal law enforcement in the sense of crime prevention. This is, again, from the point of view of fundamental rights, obviously not a positive development, but it's also one which, again, it's just a development, and how the law should respond to this. Now, interestingly enough, and quite excitingly, the German Constitutional Court, I think this was about a month ago, held in one of the key decisions on the fallout from the Snowden affairs in relation to Germany's participation in the intelligence community in basically surveying internet communications through a node near Frankfurt, which they were asked to basically by the US. And the German Constitutional Court held that the German Constitution applies to the extraterritorial activities of German intelligence agencies. So their activities will be measured according to the standards of the German Constitution, obviously including the right to the secrecy of communications. And this looked at, I mean, obviously this is a German national law, but looking at this from international law, if international law would come to a similar doctrine, then I think that would be obviously a major victory for fundamental rights standards. So that's probably where we have to go. We have to accept a degree of extraterritorial investigative powers, because that's simply what is demanded. But at the same time, we have to get to a stage, I know it is very idealistic and this won't happen tomorrow, but that we have a similar system in relation to fundamental rights. So we need extraterritoriality here too. Also, I mentioned the interesting early notions and conflicts of jurisdiction and cyberspace. There was a famous article by Johnson and Post in, I think, 2001, where they argued provocatively that cyberspace basically forms its own jurisdiction, and therefore national jurisdiction, national sovereignty should not apply. I think this wasn't meant necessarily as a serious legal proposition, but it was a provocative statement, basically saying sovereignty, you just have to accept that you have less power over this space. And obviously cyberspace is not a space, and I think even a social media platform, although you could say it's a community of sorts, it's not a separate space. In modern times, talking 2021, I guess the equivalent is that people now talk about data sovereignty, acknowledging the power of data, and therefore to what extent. And I think it's a term which is very ill-defined. It doesn't really relate to state sovereignty, but I guess it raises the question to what extent states should have a right to have sovereignty over the data in their territory. But also the other aspect, I think it's used in relation to individuals as well. So to what extent should individuals have power over their own data? So sovereignty not attaching to territory, but sovereignty attaching to data, which I think again is more an intellectual concept than a real concept, but it's interesting because in a way it's an analogy, I think, to territorial sovereignty. And talking about the idea that somehow in cyberspace actors can be freer by avoiding national jurisdiction. I remember there was this oil platform just outside Felixstowe. I don't know. You remember that story about the Sealand case?
Yeah.
Sealand, yeah, that's right. So these are guys who basically had bought, I suppose, or used this decommissioned oil platform. It's not an oil platform, actually. It's a platform. I think it's some sort of old Second World War military installation. They occupied that and then basically said, this is Sealand. And the commercial idea behind it was that they could host on a server I don't know, pornography, gambling, any of these, and that's how they would make money. Clearly, this sovereignty in inverted commerce was never challenged, and I'm not sure whether the venture was ever sufficient. But to me, that in a way was a personification of a concept of the sovereignty of cyberspace. But I think we've moved on since then. But I think in many ways, the debate about self-regulation of social media platforms goes along similar lines, to say that essentially the gatekeepers themselves should have sovereignty over their sort of domain. Another point which was raised is the double jeopardy or ne bis in idem, which I briefly mentioned in the book, which I think is of particular relevance, as Alisdair has pointed out, in respect of multi-jurisdictional crime. Is a cyber attack one crime, or say something like a WannaCry? The WannaCry malware is the attack. Is that one attack, or is that an attack, or is it 150,000 attacks if that's the number of computers it infects? And while the doctrine is obviously well recognized within a particular jurisdiction, it's not well recognized internationally, which in some ways, when I started researching this area, was a surprise to me, because as trained lawyers, this is one of the doctrines we learn early on when we study criminal law, that no one should be prosecuted for the same crime twice. So this seems a self-evident concept that it's perhaps a surprise initially when you study this area that it doesn't apply internationally. And I think this Studebaker case was a good example of that. There was also, I think, a prosecution of in the computer misuse area. There was a Romanian hacker, which I think was prosecuted in Romania and then passed on to the US authority, where he was prosecuted again, because there was a particular US dimension to his computer misuse. So I guess the argument for separate prosecutions is that penalties vary enormously in different countries, and I think, as Alisdair said, the need in a way to deter or protect. I guess there's an element of the protective principle that each state should have the right to protect their own population, and therefore it should be a separate crime. But again, it highlights, I think, the deficiency of the international system for not being able to develop a doctrine of comity which would deal with those sort of multiple crimes. We're very far away from that. I can't see this happening in the near future unless either Cedric or Alisdair see a way of this being discussed. I mean, I'm quite impressed by bodies such as Eurojust, or, you know, there's some, I guess in the European sphere, we now see a sort of coordination effort, which leads obviously to a harmonized European criminal law, which has its detractors as well, of course, but at least it is an example of it happening, I guess. The US Cloud Act also obviously is based on the idea of comedy, but I think my main criticism here is that it sort of seems to prejudge a state's human rights situation. So it basically says, oh, you know, this country has good human rights record. With this country, we can enter into an agreement. When really, I think human rights can only be judged really ex post, not ex ante. So I think that approach, I think, in terms of fundamental rights perspective, is actually dangerous. And then finally, I think this lacuna, this lack of international coordination, leads ultimately again to a might versus right perspective, where the possibility or the potential to prosecute really depends on where the accused is located, who can get hold of the criminal and who can get hold of the assets. And again, that's just the geopolitical reality again. The UK traditionally has been obviously has exercised a huge restraint. I think that's, for my comparison of the German criminal jurisdictional rules in the German criminal code compared to the US case law on jurisdiction. There's a huge difference here, because obviously in English law until very recently, the last act to complete the crime would be the only place, or the English courts would only assert jurisdiction if they were the last, if England was the place where the last act to complete the crime was actually carried out, which is a very, very narrow concept of jurisdiction. So there's a lot of self-restraint under the English common law doctrine, even though obviously that has now been changed to what effectively is the targeting test in Shepard versus Whittle, by looking at looking at all the factors, all the circumstances, and then the court has to decide where was the substantial measure of the crime being carried out. So hopefully that's picked up some of the points raised by Cedric and Alisdair. I'm sure I haven't covered them all, but I tried to respond to some of them. Thank you.
Well, thank you so much for doing that, and indeed for adding to what is already a significant contribution to the literature with some thoughts for the future, and perhaps even the next book. Although perhaps that's a deeply unfair thing to say as we launch this work that spanned a number of years. That actually takes me to my first question to all three of you, which is this. You know, we've already heard mention of, this was a book that was being written while Brexit was happening or being worked through, and sovereignty was very much on the agenda. But there's also been, venture to say, an ongoing reassessment of the relationship between states and large technology companies as actors. The European Commission has, over the last 2 years, launched multiple communications, recommendations, initiatives, and so on that seek to sort of think about pan-European regulation in the technological area in lots of different ways, perhaps less cautious than might have been in the past. That's met some backlash in the United States and elsewhere, but even now in the US with the new administration, we see multiple committees of the incoming Congress holding hearings which at least seek to hold the leaders of technology to account. So there's an awful lot happening. at the moment. And I wonder whether the panel thinks that there is a higher level of political interest in some of the questions that we've been talking about today, whether that might lead to, perhaps not today or tomorrow, but in the medium term, the types of coordination or even binding instruments that a number of you have already mentioned, or are we seeing as some US scholars are putting it, the day of the splinternet of the European Union and of others exercising their sovereignty in a way that will inevitably lead to a fractured or fragmented or divided network. So asking the panel to kind of put on their long distance vision or grab their crystal ball from the side, what are the prospects for harmonization, cooperation, coordination at the international level on the topics that we've been talking about this afternoon? Cedric, given that you put this as your parting shot today, I wonder if I could turn to you first.
Yes, sure. I agree with you, Daithi. There's clearly more political interest. Think also about antitrust. I remember in 1998 there was a comity agreement between the United States and the EU on antitrust enforcement, not joint antitrust enforcement, but rather coordinating, relying on comity. So maybe that agreement could also be used in this field. Regarding data privacy, of course, we're very much looking forward to the next iteration of the privacy shields between the United States and the European Union. So that's a bilateral issue. I don't think there will be multilateral solutions. It will be unilateralism, coupled sometimes with what we call minilateralism or bilateralism. So I think that's the way forward. At the same time, we also need the tech companies, the private companies. I talked about the production audits. They are directed at the tech companies, at the private operators. So you need them as gatekeepers of the governments, in fact. So there's a lot of hybridity there. So these were my first thoughts regarding your question. Thank you.
Alisdair?
Yeah, I think it's interesting. And I think Julia's point about Eurojust is quite interesting. When you look at that and what they're trying to do within the EU confines, that's quite interesting. And you're certainly seeing, as everybody knows, a lot more attempt at harmonization. I mean, what's interesting, of course, is it's instrument versus practice. So for example, one of the things Julia mentions in the book is the directive on sexual abuse, child sexual exploitation, which, tries to closely harmonize laws. But if you actually look at the commission reports that looked at its implementation, N years after it had been implemented, there was massive disparity still. But you can see how that might help. I mean, I think I agree with Cedric. I can't see there being this sudden rush to an international agreement on everything. That said, I think you could see it with certain topics, so like the antitrust was a good example. You can see there will be shared areas. And to some degree, it's also about geopolitical influences. So for example, at the moment, we tend to look at the EU as a bloc and all the rest of it. It'd be interesting to know, the G7 a few years ago experimented about looking at some areas beyond economics. If they continue that, you could see if there was if the G7 agreed to, deal with certain matters, that would actually encapsulate a large proportion of things. So I don't think you're going to get a rush to, treaties and everything, but I think with specialist areas, you may well find that states start to agree that it's in their interests to do it. And the reality is, the bigger the blocks, you only need a small things. So if the EU and North America agree, that's actually quite a sizable amount of where the internet is housed that could actually be encapsulated. But I just think the politics of it as such that I think that, I think when it comes down to it, it's very difficult for countries to actually deal with it in that way and say, actually, it's okay, we'll go second or we'll go third, or we just won't decide. It's okay, we'll let you do it and we won't do anything, or we'll offer you anything without the others. And it's challenging, I think.
Thanks very much. Julia?
I guess the Schrem's two decisional judgment was very interesting in this regard. I think so. Again, the reality is that, you know, Europeans use all these US American technologies, you know, whether it's Google, Amazon, or Facebook. And while on the face of it, the GDPR has been obviously a very brave attempt to increase online privacy standards and try to export them to the rest of the world, obviously through the limitations on export of data. And obviously, Max Schrems has been very successful, incredibly successful in a way, in a way, sort of raising this up to the international level, and obviously Irish data protection commissioners level, and then ultimately now, in a way, destroying the privacy shield. And interesting enough, that is to a large extent about effective judicial redress for European data subjects in front of US authorities. But realistically, I'm not really sure this is going anywhere, because the EU has no choice but to find a compromise in this matter. And the business model, the free business models are so well entrenched now that I can't see that these business models will change through a piece of European regulation, no matter how, you know, from an idealistic point of view, that's very desirable. But in practice, I don't think this will happen. And I think the other reality is now that states everywhere, whether that's in the EU, the US, or China, have woken up to the possibility of big data and data surveillance. And the states actually themselves are more interested in using this data for their own national security agenda. And I'm not really sure how strongly the states will be advocating our privacy in this respect. And then, of course, the new power on the block is China, which naturally is obviously separated to maybe English not being so dominant in China than it is, say, between Europe and the US. And so China is almost building its own internet, which again is probably based more on surveillance and social conformity. And I'm sure China will use its influence in, for example, African countries to deploy that model of the internet. And so I think it's perhaps too limiting just to look at the EU-US conflict. We need to also look at the rest of the world. Interestingly, so looking at the US pressure on social media companies to do something about illegal contents, and this is now, in a way, maybe that's a positive example of how a common problem, you know, after the terrible attacks and outrages against the mosques in New Zealand, there was an international outcry that these social media platforms must do something against live streaming and making their platforms safer and less penetrable for terrorist content. So that's an example where I think the international community can suddenly rally around a common objective, and which then isn't just limited to states' agenda, but also the platforms have no doubt or are developing technologies to deal with this particular issue. But ultimately, again, it's a very complex issue which should be more governed by law than it actually is. We see that also reflected, for example, as I say in the book, in the terrorism directive, kind of allowing social media platforms to take down content which approximates in some way to hate speech rather than looking at proper legal standards.
Thank you very much. We take a round of questions now, and combining a number of questions that have come in through the Q&A in the broad area of what we've been terming investigative jurisdiction. And again, because each of the panelists touch on this in different ways, I'll give a couple of points and allow each to respond to those of most relevance to their work. So we have one question around whether the emergence of investigative jurisdiction is tied to public law in particular and government access to evidence, or how relevant this might be, for instance, in cross-border civil litigation, We have a question specifically on production orders, wondering whether the EU response here might be, in due course, to require the US players to mirror their servers within the EU, and therefore neatly sidestep some of these constitutional and sovereign issues in the United States. We have a request to comment on the, again, already mentioned in some of the responses, on the interaction between the Cloud Act and the FISA provisions in the US. And I suppose a question that ties those three together about whether there is an emerging consensus or an understanding around investigational jurisdiction as an area where there is possible consensus, or at least greater understanding of the significance of the ability to sort of follow the data, even if setting aside some of the questions around people and individuals and enforcement of judgments and so on, whether this is a kind of an aspiring area of harmonization or consensus. So across to the panel now on a range of issues in investigative jurisdiction, production orders, etc. Perhaps going in the same order again. Cedric, if you'd like to kick off on that.
Yeah, thank you, Daithi. I think it was John who asked that question on investigative jurisdiction. Is there a consensus? I would say certainly there is no consensus. Even in the West, there is no consensus. Look at the European production order. We've been debating that for years. So I'm not sure whether we will be able to adopt a regulation this year. And if you go beyond it, the Council of Europe, you have now this draft second additional protocol to the Budapest Convention. But also there's a lot of discussion. It's all about these production orders with lots of opt-outs, and at the end of the day, the bottom line is just voluntary disclosure. So what are we talking about? And this is just the West, right? So if you go beyond the West, if you look at Russia, if you look at China, I mean, these countries that require data localization, I mean, they're not interested in extraterritorial production orders, and they would even oppose such orders if they come from the West. They would consider them as a violation of territorial sovereignty. They really stick to the territoriality principle. So you really see a bifurcation here between the West and the non-West, I would say, and perhaps regional law may emerge in the West, but definitely not universal law. I think Jessica had the question on investigative jurisdiction also in civil litigation. I think it was Dan Svanteson who actually coined the term in a private law context, definitely not in a criminal law context. But even the extraterritorial production orders, they're actually based on civil discovery orders, as they used to be. I mean, they were quite popular. Or controversial, I would say, in the 70s and the 80s, were seen as extraterritorial. So this is just the next step, I would say. And even the European Commission, in its proposal for the EPO, refers to this US practice of discovery orders and saying, well, it's no big deal. It was actually accepted under international law, while forgetting that especially the Europeans were actually livid when those production orders were issued by US courts. And that was clearly in the civil context, so that has not changed. So my reply to Jessica is yes. I mean, they come from the civil law, so they can also be used there. Then we had this question by, well, I only have the initials, MM, requiring US tech companies to mirror US servers in the EU. So that would be a form of data localization, I would assume. It's a bit what Russia is doing these days. So you would have direct access. You don't have to produce these production orders. I mean, you just have them on your territory because the server is territorial. So you're no longer talking about extraterritoriality. My question is this. I mean, this could be feasible for big tech, but is it feasible for startups? I mean, it comes with an additional cost. So I'm not a tech guy, but I can imagine this doesn't come cheap. And also, more from a global policy perspective, what kind of message do you give to more autocratic states if you also go for data localization? Okay, we're a rule of law-based society. We don't do anything wrong. But think about more autocratic states. They would say, well, the Europeans also do data localization, so don't criticize us. We do the same, and they might do it for other purposes. So perhaps it's not wise from a strategic perspective to require this kind of data localization, even if it's just mirroring. And maybe a final point regarding Andrew. Andrew had some concerns also. Daithi, you mentioned that over the US Cloud Act, privacy, US law enforcement agencies accessing basically data of people everywhere in the world. Well, I tend to agree. I think there are two issues here regarding data transfers. As I said, I look forward to the new iteration of the US-EU Privacy Shield after Schrems 2. Will the Court of Justice strike down the new iteration? What will the European Data Protection Board think about this? I mean, there has been a new guidance just a few months ago. They seem to be quite strict in terms of equivalence, so I don't know whether that will be possible. How much comity can we give in this case to the United States? And regarding production orders, of course, the next important issue is the content. The substance of the bilateral agreement between the US and the EU. There is already such a bilateral agreement between the US and the UK, and Julia probably knows more about this than I do. So some digital evidence, so extraterritorial production orders, basically. Now, of course, the EU is a rather powerful actor. Think about the Brussels effect, the famous book. They have some power vis-a-vis the United States, but as Julia also describes in her book, other states may have far less power and may not be able to get concessions from the United States in terms of privacy protection for their own citizens. So these agreements are likely to be skewed, if ever there is such an agreement, they're likely to be skewed in favor of US interests and not really in favor of the interests of data users. So we can, being based myself in the EU, I can consider myself partly lucky that the EU has this bargaining power quite probably vis-a-vis the United States, but other countries clearly do not have this power. Thanks.
Thanks very much. Alisdair, what's your perspective on these?
So I'm not sure I can add much to Cedric on that, so I'm going to kind of throw a slight curveball on it, which is looking at it from kind of an analogy. So how companies are dealing with encryption perhaps shows us some of this. So Facebook and stuff are going to end-to-end encryption at the moment. Why are they doing that? Actually, because production orders, cooperating with investigations and stuff is a complete pain for them. It costs them money, it causes reputational harm and all the rest of it. I think what you'll see is companies trying to ensure that these jurisdictional issues don't come up. So I kind of half joked about, a few years ago, Google experimented with servers on barges. Actually, the amount of money Google has and others, why don't they just build offshore platforms that are outside of the jurisdiction? And it's that housing thing. So I think you will start seeing companies reacting to this and actually trying to take steps to avoid it. And as I say, I think you can draw an analogy to encryption. And one of the shifts towards encryption, they like to say it's because it helps users and it's privacy and all the rest of it. Actually, when you talk to the CEOs, quite often it's not. It's about actually, if we can't give you the data, you can't come and ask for it. And I think you will start seeing companies trying to work out how they can be in a position whereby they don't give data or don't have to give data. And I think, so I see this as being an interesting chess game between individual countries, groups like the EU, and collectives and things, and the companies. Of trying to work out how to either get data or avoid giving data, because it's not good business to give data routinely. And as you say, there's, the growth of China and others means that they will start saying, well, we want that as well. So if you mirror the EU, then China's going to say, well, we want the mirror, and Turkey wants the mirror, and others want the mirrors. And it's, depending how you do it, it becomes more problematic. So I can see companies trying to kind of fight against that by trying to be in a position whereby they can't give any data, so that production orders and stuff actually start becoming slightly more irrelevant.
Thank you. Julia?
On the first question of whether the emergence of investigative jurisdiction is also relevant in civil cases, I think in civil cases there is less of a reluctance. I think to, generally speaking, in civil cases there's less of a reluctance to actually to enforce and follow the ruling of a foreign court. So I guess if you have a court in country A, a civil court in country A, asking for evidence, country B theoretically might be more inclined to actually follow this. And I think in the US, the use of subpoenas is supposed to allow a court in the US to issue a production order to a, say, European subsidiary of a US company, and that is directly enforceable. There is obviously also an international instrument, the Hague Convention, which deals with the exchange of civil evidence, which provides mechanisms to mutually enforce through proper channels a sort of civil court's request for evidence. But I think there is less at stake in terms of state sovereignty in civil cases than there is in criminal cases. Now, obviously, we have seen for years and years and years, and Cedric actually describes these really well in his book, the conflict between US subpoenas and then European reluctance to, or basically a conflict of law where the European company is reluctant to follow the subpoena for data protection reasons. So this has caused obviously huge questions of jurisdiction in this particular area, where we have similar problems, I think, from a conflicts of law point of view. Then the next question, Claudia, you ask about the Budapest Convention and why, in a way, why it didn't address jurisdiction or comity. I guess the focus of the Budapest Convention was the harmonization of the enforcement powers and investigative techniques. So there was, I guess, the purpose of it was to harmonize minimum investigative powers in the different countries, and jurisdiction, I suspect, was added as an afterthought. In a way, that would have required a whole set of difficult negotiations, and I guess you can only do so much in one convention. You also asked whether it would be better to narrow the jurisdictional principles that allow the states to prosecute cybercrimes, for example, to limit it to only the territorial principle or the principle of active personality. I guess it'd be very difficult for states, if they have in their own national criminal law principles which go wider than these principles, to ask them for that kind of restraint. So I think it'd be very difficult to agree this in an international convention. Or would it, and then you, obviously a logical consequence, you ask whether it's desirable to consider alternative ways of solving conflicts of jurisdiction, for example, establishing cooperation mechanisms. I think this is very desirable indeed. It's not easy to do, again, because of the question of sovereignty, but I think in a way it's less of a question than a conclusion, and I entirely agree with your conclusion. But it will take many years before we see any of this really happening, I think.
Fabulous. I'd like to share two comments or questions that have come in the last couple of minutes with the panelists and ask for their response. And they both, again, look to what next, but also ask us to think about the concept of territoriality, particularly in how law and politics interact. So Professor Ute Kohl asks, might it be argued that territoriality is not withering away at all, but in fact witnessing a heyday? After all, states have access to their populations' collective and individual locations and locations of their activities through the data collected by private platforms, and thus can exercise territorial oversight as never before. Professor Paul Bernal then adds from a different direction, highlighting how the UK government, and in particular Oliver Dowden, in talking about data protection law and the opportunities, as Dowden puts it, for the UK in the post-Brexit world to strike out and make a different balance and take a different approach to regulatory issues. Paul asks, is this a sign of worse things to come? So Uta asking about the attractiveness of territorial approaches to states, particularly in light of what's feasible now in technological terms, and Paul looking at the UK example of how the temptation to take a different approach to try and maximize the effect of national law in various contexts, including data protection, might be tempting for the UK. So two very provocative and interesting comments from esteemed commentators, and we'll work our way through the panel on this. We've got a couple of minutes remaining, so certainly like to hear what the panel think on this, starting again with Cedric.
Yeah, thanks, Daithi. And Uta, great question. Great to see you again. Yeah, the heyday of territoriality, or territoriality back with a vengeance. Yes, why not? I mean, states have access via geolocation techniques to our internet activity. They know maybe not exactly what we're doing, but they know where we are. So, and this is a return of the state. It's not just China, it's not Russia, but it's also Western states. So I tend to agree with you. And related to this is a whole discussion on digital or strategic autonomy and more control for the state. I hope it doesn't mean that it's necessarily data localization. I hope it's something else too, that we also stand for our values, our Western values of an open internet. That remains important for me. There was a related question, Daithi, if I may, on territoriality as a proxy for something else, because I believe it relates to Uta's point. I think the point here is maybe we should go back to basics. What is this something else? And maybe the something else is genuine connection. At least that was Frederick Mann's position in his Hague lecture in 1964 on jurisdiction. That's one of the basic texts of jurisdiction. So all the permissive principles of jurisdiction basically derive from this overarching principle of genuine connection, which you now find in the restatement of U.S. foreign relations, the fourth iteration, just out, basically. And it's also what Dan Svantesson says. I mean, he's going quite far. He's saying drop territoriality and just look to second tier or third tier principles. But he also refers to genuine connection. He also refers to reasonableness, comity, interest balancing. I mean, maybe this is what we have to do. And if you look at production orders, they don't look at territoriality as such. I mean, territoriality is not really the relevant issue here anymore. It's no longer about the location of the data on a territorial server. It's about different connections. So we are going beyond territoriality here. Thanks.
Thank you. Alisdair?
Yeah, I mean, I think I would agree with Uta. I think it is a resurgence. I mean, I think, you as Cedric said, the amount of data that the government can access about us and want access and, want to retain access or, getting more and more data around it. It is around, effectively the resurgence of territoriality. And I think there is probably, I think you probably are seeing that. I guess, it ebbs and flows and perhaps this is a flaw, but yeah, I don't think I have much else to add to beyond what Cedric said. But I think we are true. I think you're seeing that, and I think again when you look at political situations around, we're talking about splintering before and all the rest of it, where you see that, where you start seeing emergence of rival powers and stuff, territoriality tends to grow at that time, and we're certainly at the point where we are seeing a shift in geopolitical powers. In terms of technology, technology is allowing new parts of the world to become big actors in a way that would have been difficult under more traditional metrics. So I think territoriality is definitely increasing because of the changes of geopolitics.
Thanks very much. Julia, turning to you now, this is of course something that you start to set out an agenda for in your conclusion, and you bring your detailed analysis back to a question of global power and balances, and indeed the fundamental rights question, which you've identified as running through. But interested in your response to Uta's provocation and indeed to Paul's question.
Thank you, and thanks, Uta, for posing this comment. Hi to you. I agree. I mean, in the sense that a state's power is no longer limited to the territory as it was before, because it's simply possible now. But I guess in the old days, it wouldn't have been easy to enforce directly in a foreign country. Now it's obviously very possible to hack into foreign computers and to collect data, which is strictly speaking stored in another jurisdiction. So in terms of the might, but not necessarily the right, territoriality plays less of a role, simply because a lot of these powers can be exercised extraterritorially. But this doesn't necessarily mean that this is legal. I think that it's also important to distinguish between legal powers under international law and what can actually be done. Of course, the problem with international law, of course, is that state practice informs the scope of international law too. So if all states are doing it, there's potentially an argument that this is a legal practice under international law. And again, that is in a way what we see or is the problematic nature of international law, that it is to some extent determined by state practice and not by any written or fundamental principles. It is also interesting that actually I was speaking yesterday to the Department of Culture, Media and Sport on the current review of the Gambling Act, and there's increasing evidence of the massive harm and increase of gambling addiction, especially now partly because of lockdown and people becoming more vulnerable to exploitation by online gambling, online betting and online casinos, etc. And so in terms of regulation, the interesting question is to what extent regulators themselves should use and govern the AI technologies which the gambling companies obviously use, because obviously gamblers are being profiled and then their proclivity to gambling is exploited through AI technologies. And in a way, I think states need to regulate and in some extent deploy these sorts of technologies themselves to ensure that they're used for good practices. But it seems we're in a strange position where on the one hand we say states need to recognize online privacy and limit data protection, but we're now moving to a position where we're saying you need to collect this data, but you need to use it in a way which is beneficial rather than exploitative. So again, I think this underlines in a way the conclusion that perhaps a lot of this is also about data sovereignty. So territorial sovereignty has perhaps less significance than actually sovereignty and the ability to manipulate and govern data through technology. And again, this is not a legal point, it's a factual point, which arises, I think, effectively from the technology. Paul, again, hi, really lovely to see you here. I think the GDPR and obviously having left the Brexit, the withdrawal from the EU, it's partly about obviously UK divergence from the GDPR, but I think the main risk here is also now the UK is not part anymore of the coordination procedures under the GDPR. I think the UK is actually completely losing its engagement and its cooperation. I think the fact that the UK basically isn't cooperating anymore. So it's not just about are we having lower standards than the GDPR, because obviously we're now in charge, we are sovereign over our own laws. More importantly, I think the UK is now excluded from the cooperation mechanisms in the GDPR. And that means that it's even more difficult, I think, to align the UK with what's happening in the EU. So it's not just about the actual standards in the GDPR, it's also about the lack of cooperation and the UK's self-exclusion effectively from the European Data Protection Board.
We have just reached the end of our time together this afternoon, so I would like to thank both Alisdair and Cedric for their remarks, both in the initial phase of our discussion, but also in responding to the very wide range of questions that that have been prompted. But of course, those questions are ultimately prompted by the book that we're here to launch and to celebrate, and indeed to encourage you to all who are on the call this afternoon to acquire or to read at the earliest possible opportunity. I think all of us endorse its merits and its contribution to our understanding of the area, as all of us have said, in such a wide-ranging and holistic fashion. With that in mind, I think it only appropriate, therefore, to give the final word to Julia as the author, to any other comments that you would wish to make in terms of the book itself or in terms of our discussion. But I will pass it to you at this stage, while thanking Alisdair and Cedric for their contributions, thanking Christine at Queen Mary for the setup of the event, and to all of you for attending. But Julia, over to you, and many congratulations on this fine publication.
Thank you very much. It just remains for me really to thank the panelists, Alisdair, Cedric and Daithi, for chairing this. It's obviously a very wide-ranging discussion. I think hopefully we picked out some of the interesting themes. I also want to thank the participants. Thank you for coming along, and I'm sorry we couldn't deal with all the questions in a halfway sufficient way, but I think we'll probably be here all evening. So let me wish you a nice weekend, and thank you again very much.